Let's talk about what happens when a previously removed illegal alien is arrested a second time by ICE. How do things work in that situation? Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. There's been a lot of misinformation about the process through which illegal aliens who have previously been deported or removed from the United States are removed a second time if they return and are caught. While an illegal alien who has been caught in the United States and has not been previously removed is entitled to minimal due process, the due process protections for someone who has been previously removed are greatly reduced, and it's important to understand the distinctions here. When an individual who has previously been removed or deported re enters the United States illegally and is apprehended, the United States government follows an expedited process that differs from the standard removal proceeding. I'm going to outline the process and tell you where you can find additional information within the Immigration and Nationality Act and the U.S. Code. If someone who has previously been deported is arrested by ICE, they are fingerprinted and their records are checked in immigration databases like IDENT and the FBI's IAFIS or IFIS. If there's a match to a prior removal order, the Department of Homeland Security may proceed with reinstating that prior order under INA Section 241A5, or you can find that at 8 USC Section 1231A5. The reinstatement of removal process allows ICE or CBP officers to reactivate the prior removal order without starting a new court proceeding. You may ask, why is that? Where's the due process here? Well, the due process was granted the first time he was removed, and they did not find any reason not to deport him then. And the presumption is that that order, that he got all the due process he was deserved previously, and now it's time for that person to again be removed. And again, this is under 8 USC section 1231A5. If the Attorney General finds that an alien has re entered the United States illegally after having been removed, the prior order of removal is reinstated from its original date and is not subject to being reopened or reviewed. What this means, the person is not entitled to a new hearing before an immigration judge. No appeal is allowed from the reinstated order unless there's a legal exception, and there are two of those. One of them is withholding of removal, and the other is the Convention Against Torture Protection. We'll deal with those here in a moment. Limited relief options. Despite the streamlined nature of reinstatement, the individual may request certain forms of protection if they fear return to their home country and if that fear is reasonable and not wholly made up out of whole cloth. So that occurs in what's called a reasonable fear interview. If the person expresses fear of persecution or torture, they receive a reasonable fear interview with an asylum officer, not the typical credible fear interview used for initial asylum applicants. If the officer finds a reasonable fear exists, a case is referred to an immigration judge for a withholding only hearing. Now, the information is found in the Code of Federal Regulations, 8 CFR 208.31, procedures for aliens subject to reinstatement who fear persecution or torture. Second removal. If the reinstatement is upheld and no protection is granted, ICE may physically deport or remove the individual again, often to the same country as before. This is typically faster than an initial removal because there's no full immigration hearing. Also, there are criminal consequences for re-entering after prior removal. It is a federal felony under 8 United States Code, Section 1326. Basic illegal re-entry is up to 2 years imprisonment, And if the person has prior criminal convictions, it can go up to 20 years. Now, I suspect in most cases they make a deal with the individual and say, we won't prosecute you criminally if you let us deport you. And I think most people probably take that deal. Often the government will prosecute under Section 1326 and then deport after the sentence is served. So here is a summary of the process. ICE arrests the individual. The Department of Homeland Security confirms prior removal by fingerprint and issues a reinstatement order. The individual may request protection if they fear return. If no protection is granted, they are deported again. If prosecuted under 8 U.S.C. Section 1326, they may face prison time before removal. I mentioned the withholding hearing and the Convention Against Torture. A withholding only hearing is a special type of immigration court proceeding available to individuals who are subject to reinstatement of a prior removal order. That person is somebody who fears persecution or torture if they are returned to their home country. It is limited in scope and does not allow for typical forms of relief like asylum, cancellation of removal, or adjustment of status. Below is a detailed explanation of the process and legal standards involved. To reach the stage where you get a withholding only hearing, three things must happen. The person arrested by ICE and found to have a prior removal order is verified by the DHS, and that removal order is reinstated. That's number two. The third thing is the person then expresses a fear of persecution or torture if returned. This triggers this reasonable fear interview with an asylum officer. The asylum officer determines whether the individual has a reasonable possibility of being persecuted or tortured in their country of origin. Now, reasonable possibility is lower than more likely than not, but the burden of proof is on the detainee. It's on the illegal alien. It's not on the government to prove that he doesn't have that. So, if the answer is yes, the case is referred to an immigration judge for a withholding only hearing. And if it's no, the person is again deported immediately. The person may request review by an immigration judge, but if the immigration judge upholds the denial, the person can be removed. Withholding only hearing. This is a limited scope hearing where the immigration judge only considers whether the individual qualifies for withholding of removal under INA Section 241b3 or 8 USC Section 1231b3 or protection under the Convention Against Torture 8 CFR Section 1208 Sections 16 through 18. Importantly, the judge cannot grant asylum, cancellation, or adjustment. The prior removal order remains in effect and is only withheld, not canceled. The legal standards for relief for withholding of removal, the person must show that it is more likely than not that their life or freedom would be threatened on account of race, religion, nationality, membership in a particular social group, or political opinion. The burden of proof, again, is on the applicant. Country conditions and credibility play a big role. The relevant law is found at 8 United States Code, Section 1231b3, and 8 Code of Federal Regulations, Section 1208.16b. Now, for protection under the Convention Against Torture, the standard is that a person must show it is more likely than not that they will be tortured by or with the consent of or acquiescence of a public official if they are returned to their home country. The protection does not require a nexus to race or religion or anything else. And the relevant law, again, is 8 CFR 1208, 16, 17, and 18. Outcome. If granted, the person cannot be deported to their home country, but they remain under a removal order and they may be indefinitely detained or released under supervision. If the withholding of removal is denied, and the prior order is executed and the person is deported immediately. What you probably noticed there was that all of this happens solely within the Immigration and Naturalization Service, INS. It's either an immigration judge working with ICE or with the Customs and Border Protection people. But it's an immigration judge, an Article 2 judge, not an Article 3 judge. It's not a district court judge that makes these determinations. A district court judge is sometimes necessary to grant a warrant for arrest. If ICE identifies someone and knows roughly where they are, and they think they are being harbored in a particular location, for example, somebody's house, then the ICE agent has to go get a basically an arrest warrant from a federal judge because that is what allows them to enter into the residence and go get the person. That's because that's granted under Article 3. The immigration judge can't effect an arrest in a private residence with its warrant. That's because it's an Article 2 warrant, not an Article 3 warrant. And the difference is obviously the two branches of government. Only the judiciary has the ability to grant warrants that are available for entering into private personal spaces, spaces where people have a reasonable expectation of privacy. Most places are not like that. Now, bathrooms, you have a reasonable expectation of privacy, but assuming that you're a male and the people who are coming to get you are a male, hiding in a bathroom isn't going to do you much good. Plus, it's an awful place to take your meals. In addition to that, if you are out in public, if you're walking on the street, a warrant from ICE is just as valid as an Article 3 warrant for your arrest. So, hopefully, that explains some of the things that are not real clear necessarily, and that, frankly, neither the media nor the federal government have made very clear during all of this thing with Kilmar, Abrego, Garcia, or any of these other folks who have been arrested and detained subject to removal orders that have previously been granted. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.